All right, I hope everyone can hear me. Greetings and salutations. I am Keith Green, and I appreciate you all being here today. We're going to go ahead, let me get myself together here, get us started. Welcome you all, first of all. Again, welcome on behalf of our president, Michelle Hoball. We appreciate you all attending our workshop today. I'm Keith Green, and I am your educational director for OCHAR. And again, we appreciate you being here. The way the class is going to go today, we're going to go through some of the forms, not all of the forms, regarding the residential aspect of the forms. Now, there are some other changes that were done to other aspects of real estate. For instance, there were forms done for the commercial auction, but we're going to cover residential. So after we go through this, then we will go ahead and have a question and answer session. I'll do my best to answer some questions regarding the form changes. Okay, so you can either jot your questions down or just make sure you have note of them so that I can go ahead and answer them. And if you cannot hear me, just let me know, but I should be coming in loud and clear. All right, so what are our objectives for today? Well, our objectives are to what? Identify, by the end of this class, you guys should be able to identify the changes made to the following residential forms. We're going to talk about the offer to purchase contract. We're going to talk about the offer to purchase contract for new construction, offer and purchase contract for vacant land, some of the changes that were made to the new construction addendum, the setup of possession after closing, as well as the buyer possession before closing. We're going to talk about the agreement to amend the contract, the exclusive right to sell listing agreement, and the referral agreement. Now, so I said earlier there were some changes that were made. There were 26 residential changes made to the residential side of real estate in terms of forms. There were 20 commercial forms that underwent some sort of change, and there were 7 forms that went under change in property management. Out of those 7, they created 4 new forms for property management. And then, of course, under auction regarding real estate, there were 6 changes made to some of the forms. I'm getting a text message. There's some people that want me to send them the Zoom link. Cover, if you can hear me.
On it.
Okay. Yes. All right, so let's look at some of the changes made. All right, so the first thing we're gonna look at the offer to purchase contract. We're looking at paragraph 1C. And the thing that they did with this was just to add the manufacturing homes or mobile homes. And they just added that part to paragraph 1C. Just to make sure that everyone knew that, where it was, where it is in the form, so that these things can be easily identified. And so these check boxes were added for mobile homes. Regarding the paragraph 1D, what changes were made to paragraph 1D? Talked about earnest money. Now, before the old form had on there that it would be delivered effective by the effective date. They took that out, and they just said, we have that box that says electronic transfer within 5 days. They put that in there, and it is just saying that there was some confusions early on as to when the earnest money was supposed to be given or when it was supposed to be provided. So now what they're saying here is, let's just make it effective 5 days. 5 days of the effective date of the contract, and not on the effective date of the contract. So that's one change that was made regarding the first part of the offer to purchase contract. When it comes to the fixtures, couple things that they added to this paragraph or to that list there. They modified where it had the swimming pools. They included the exclusion of inflatable spas and hot tubs. Many people have inflatable spas and hot tubs, I'm assuming now, and so they decided to make sure that as we look at this list with fixtures, that is excluded, so that is not part of real property. It's personal property. And then, of course, the curtain and drapery rods and brackets are to remain. They are considered real property or fixtures because they are attached to real estate. So just wanted to make sure that they wanted to make you all to make, and this is the bottom here, wanted you all to make sure that you understood where that goes and where that is. And that's in the bottom part of this list here. So those are the two changes that were made to paragraph 2B regarding the offer and purchase contract. Now let's look at paragraph 2D. Now, the next page, as we go down from the fixtures, there's this item. And underneath that, where you can write in what are some of the lease to own items that may or may not go or may not stay with the property. They wanted to add in there that lease fuel tanks, and then we're going to identify those fuel tanks in paragraph 7D, but wanted to have you understand that they do not convey. And yes, we still have houses that have underground tanks. As a matter of fact, the last closing that I had on a very high-end home in Pittsburgh had an underground propane tank that heated the stove and the heating system downstairs. So yeah, we still have those, and I had to deal with this in my last transaction as it was a leased underground gas tank. So we still have those, and so they've had some issues with people still not understanding how to identify these things and what conveys and what does not convey. And so again, if it's leased, if it's underground, particularly, it's going to stay. But if it's above ground, because a lot of houses now, particularly if you go in some of these new subdivisions, they're going to have above ground tanks that will provide heat to the gas fireplace. Okay, or provide not heat but gas to the gas fireplace. Wanted you to understand that with regard to this section of the changes, that we do not have any, just to reiterate, there's no appraisal contingencies or no contingencies regarding a person has to sell their house first before they are to purchase another one. So again, they wanted to make sure that everybody understood that. Want to reiterate that because they're still having some issues with that part of the contract. Okay. Now, section or paragraph 4D regarding the offer to purchase contract. What the commission is saying with this particular item is that if in fact a person, well, when you go view the property, that the property needs to be in the same condition as it was when you close. And we'll look at some more parts to that, but it says here the bullets speak for themselves. Unless the parties agree, otherwise the property is being sold in its current condition. Seller may, but is not required to engage in negotiations for repairs, improvements to the property. So again, it's saying here that particularly with this market that we've had this last year or so, and we've had high due diligence and we've had issues where people are not doing due diligence periods. They wanted buyers to understand that sellers do not have to negotiate. They don't have to provide, they don't have to make repairs. That's simply something that they do if they want to do, they're not required to do so. With regard to the Residential Property Owner Association disclosure statement, there were some issues regarding people saying, well, you know, again, with the high due diligence that people have been putting up in this last year with the way the market has been, there's been some people that have backed out of the contract, and a means of them backing out of the contract and trying to get their due diligence back is saying that that this form, according to the Residential Property Disclosure Act, was not delivered prior to the offer. Now, it might have been negotiated, it may have been presented during the negotiations, but some brokers were trying to make a point of saying, we need to get our due diligence money back because we didn't get it before we got the offer, although they had copies of it in the negotiation period. So what this section is saying here is, as long as it was presented prior to making the offer, that the law supports it being submitted. Therefore, you cannot decide to ask for your due diligence money back if you didn't get it right at the time you submitted the offer. If you got it, if it was provided to you as you were negotiating the deal, then that's good enough. And that's what this addition was to the contract. Here's when we start talking about the fuel tanks. Now, this is, I copied this right out of the offer to purchase contract, and I added this section to just to be a little bit more transparent regarding the tanks, where the tanks are, if they're leased, if they're not. And then there's a section at the bottom there under section II, and it talks about the seller may use the fuel tank in the described above through settlement, but may not otherwise remove the fuel and resell it. So they had some issues where sellers had fuel or gas or what have you in their fuel tank, and they wanted to remove it prior to the house changing hands. And so it's saying here, no, you cannot do that, seller. What you can do is negotiate that in the price of your settlement, or the price of your offer. If they submit an offer, make sure you can counter it by saying, hey, I have this amount of gas or fuel in this tank. So you need to pay for that buyer if you're gonna buy my house. So you can negotiate that within the offer. But you cannot remove the oil or the fuel or otherwise sell it or have the gas company come back out and take it out. That's unacceptable. Offer to purchase contract, again, we have changes that were made to this section. What they did in this section was just trying to narrow down further and make it clear who's responsible for what in terms of paying for the HOA fees in terms of transferring the property. So in the section 9 of offer and purchase contract, you'll see what the seller's responsibilities are as well as what the buyer's responsibilities are. And they're clearly laid out. And so what they wanted to do here is to make sure that it was simple, made plain, so that it would not be any confusion regarding that. All right. And these are some, again, this is what the buyer, we just talked about what the seller should pay, and this is what the buyer should pay. So again, just make sure that it was understandable, clear, and everyone knew what the responsibilities were or are for both parties involved. Now, paragraph 11A. This section, again, deals with the condition of the property. Now, what's important to understand about this section, and this is new, is that the property must be in the same condition as it was when the parties viewed it prior to making an offer. They viewed it, they liked the house, so now they're moving in, or they're submitting an offer is accepted, they move in, the condition must be the same. If it is not the same, if outside of normal wear and tear, then the buyers have a right to terminate the contract and receive their due diligence fee and earnest money deposit back. Now, what's new is the fact that they can get their due diligence fee back. But what they cannot get back is the due diligence costs. So that means that any money that you put forth for your due diligence, like getting a home inspection done, maybe getting a survey done, or getting some other types of inspections done on the property, those costs will not be refundable, but the due diligence fee will. Now, you know that if of course, the cost would be refundable if, in fact, the sellers breached the contract. But with regard to this section 11A, it's speaking in terms of property condition. Now, it also says that, of course, if the property is in worse condition, if it burned down or if it's a flood or what have you, if the buyer decides they still want to keep the property, then they have to negotiate with the seller, not negotiate, but the seller will have to provide them, of course, the cost to cover the damage, maybe through whatever they're going to get through the insurance company. But the important part of this is that buyers can get the due diligence fee back, and that's what's added, this new to the property. Attorney fees were added to this section, and with regard to attorney fees, of course, it says that that if one or the other party decides to sue, that they can recover attorney fees, and they added this section, the statute to this section, simply because in a contract, in a situation where attorney fees can be recovered, then it has to be stated, the statute has to be stated in the contract. So you'll see that here regarding that. Now we're going to move on. I'm going to stop right quick. I said I was going to do question and answers at the end, but I think I have enough time. Any questions? I have a time for a couple questions about the offer to purchase contract. Any questions regarding that? Let's see here. I got one chat question. Calendar of business days. Talk to me about when you asked me about calendar of business days, regarding which section? Mr. Child. He's not saying anything. I'll hopefully he'll come back and provide some further clarification as to what he was asking. All right, offer to purchase and new construction. Under 5C, they added that the seller under new construction must provide the pest inspection and making sure that the house is free of termites. So that was added. Let's see. Can you clarify 5D? Did you say buyers can get DD back? In terms of, let me go back real quick. In terms of this section here, if the house is not in the same condition as it was when you viewed it and it's beyond normal wear and tear, and if the buyers decide they want to terminate the contract, they are entitled to the due diligence fee. Earnest money is going to be at 5 effective days. It's going to be, if I'm not mistaken, it's going to be calendar days, not business days. But I'll get some clarification on that. But if I remember, it's calendar days. All right, so we're gonna keep it moving, and I'll entertain some more questions as I get past the next section. Any questions about offer and purchase new construction? Again, the seller's going to provide the termite guarantee, and the service has got to be done by a reputable or licensed termite or not termite, terminator, licensed terminator. exterminated, excuse me, I said terminated, exterminated. All right, offer to purchase, contract vacant lot and land. This section was added just particularly if someone was trying to sell a portion of land. There's some legal aspects to that. It talks about if you're going to, so if somebody has 3 or 4 acres and they only want to sell part of it, and they want to live in the other part, they may have to have that, may have to meet the guidelines of it being a subdivision. And so there's this note here that speaks to the statute relating to that. And that, if you're going to sell property, particularly if it's a subdivision, you can't sell it until it is recorded and that it's been, submitted to the registry of deeds and approved and recorded. And then you can start selling flats. So you cannot sell a lot in a subdivision without it being approved and recorded. Particularly if people are trying to take possession of it. They cannot sell it based on a picture. It has to be recorded and it has to be a real subdivision, of course. And of course, when we record it, that gives us proof that there's something there. All right, new construction addendum, new construction addendum. These 2 paragraphs were added. Let's see what it says about that. This form was not used as much as the commission and the Association of Realtors, as well as the Bar Association, as it needed to be used. They want you to understand that anytime you're dealing with new construction, particularly if it's a house, just a spec home or anything like that, most of the work has probably already been done, but if there's any type of other work that needs to be done, you need to use this addendum, okay? New construction, you need to use this addendum. If they still gotta put paint, they still gotta put drywall up, if they still gotta put floors down, you need to use this new construction addendum. They said it wasn't being used enough, but it needs to be, and so it's giving you some notes within the form about how it's to be used and why it should be used. Okay. All right, when we start talking about the buyer possession before closing and the seller possession before closing, there were some changes done to the form, both forms, and it's just a warning that's at the beginning of the form, okay? And so that's this part of it, and it's self-explanatory. If you're going to go into long-term leases, or if it's going to be for a longer period of time, then it needs to be more of a residential lease. So they just wanted you to give this warning to both the buyers and the sellers. And Meta, I'll get to your question regarding the 5D, okay? Again, here's another section to the seller possession before closing and the buyer possession, the buyer possession before closing and the seller possession after closing. It simply says that you must give the seller the right to enter the property for an emergency if that happens, and that regarding access to the property, once the property is closed upon, as closed, then the seller needs to go ahead and provide the buyer with the key and any type of access materials that they had prior to, they need to go ahead and provide that to the buyer, okay? But they just wanted, it was not clear as to what the rights were for the buyers and the sellers in these 2 forms. So they added these 2 in section 1 of both forms. And then for the buyer possession before closing, they added this section here under number 5 and didn't add it to the seller possession after closing. It says it was amended to make it clear that if the buyer possession before closing agreement is terminated, the buyer is required to return all means of access to the property to the seller. So if it didn't work out, the buyer is clear in this contract that you got to return everything that you had, keys, garage door openings, things of that nature that allowed you access to the property. It says here that you have to return those things. They added that into the contracts this year. All right, agreement to amend contract right up above at the top there, below the agreement to amend, they added which amendment this might be. They gave an opportunity to put the number down. Many times when we have these type of contracts, particularly if we have, I know when I was doing listing land, I've had to do this on 3 or 4 different times as the contracts expired. So what this saying is it helps you identify which amendment it was. Okay, so that's the first change to the amendment to the agreement to amend contract. It gives you a place where you can put what amendment number is this. Regarding the contract as well, they really wanted to speak to escrow agents. So if in fact you're changing the escrow agent, then you need to, they gave an opportunity for you to put who it's going to be changed to, from whom to who, how much it is, and that the person who's getting it is acknowledging that they received it. Okay, and so that's going to be on the agreement to amend contract. It's a new section that it was added. An exclusive right to sell listing agreement. So now we go into the listing agreement. There was some important changes made to this. Many of the changes that were made to it mirror what was made to the offer to purchase contract. Some aspects of the exclusive right to sell was cut and pasted into the offer to purchase contract, particularly that section that deals with fuel tanks. Again, this talks about the fuel aspect of it. Seller may use fuel in the tank, described above through settlement, but may not otherwise remove the fuel or resell it. And any fuel remaining in the tanks as of settlement shall be included in the sale as part of the purchase price, free of lien. So it's the same verbiage that was in the offer to purchase contract they placed in this exclusive right to sell. Again, they want to be very transparent about the tanks, whether they're underground or above ground, and how to handle if there's still fuel or oil that's in the tanks. And again, they added that note as well to the exclusive right to sell listing agreement. Home inspections. They had in this section in the original contract, they referenced the question and answer brochure that the Real Estate Commission has, and that was in the original section 14. So they took that out, and then they added it to a note under paragraph 20 in the exclusive right to sell listing agreement. And they just referenced, you know, that the commission does have question and answer brochures about several different things. And so they added that, took it out number 14 that was in the original, that was in the one last year, took it out the new one, and then added it into, put part of it in paragraph 20, then added that note under paragraph 20 of the exclusive right to sell listing agreement. Okay. All right, again, we're still in the offer of the list exclusive right to sell listing agreements. And this deals with dual agency. And so they made some interesting changes regarding dual agency. One is, if you're going to use dual agency, it gives the person the right to decide if they want an agent to work with both the buyer and the seller, or if they just want them to only work, you know, with them and have someone else do the other part from your firm. So basically, if I'm going to approve dual agency as a buyer or seller, do I want my agent to represent the other person as well, or do I prefer the firm to bring somebody else in to work with the third party? Then it talks about designated dual agency. And what it's saying here about designated dual agency is, if the person chooses designated dual agency, what they're saying is that they're authorizing and they're directing the firm to practice designated dual agency. So if they check that, then what they're saying is, we want designated dual agency. So that's one of the things that they wanted us to make sure you understood when it comes to changing these forms. At least that's the way I understood as we learned about it, is that with designated dual agency, when they check that, they're saying, hey, I authorize you and I direct you to designate an individual agent to represent the seller and a different person to represent the buyer. And it's stated here right there that I highlighted. So though that's an important change when it comes to dual agency regarding the exclusive right to sell listing agreement. All right. Termination in breach. What they did was they just reworked this section. Mediation was a different section. I think it was section 20 of the old contract. They just kind of worked everything in, reworked paragraph 18, included mediation in that particular paragraph, and they added in the attorney fees. No major change, just kind of reworking the words, reworking the paragraph, things of that nature. Now, when it comes to the referral agreement, we know there's an agreement out there that we can use if we're going to make a referral to someone. We signed the referral agreement, but what was happening here is that the firm at some point in time may have changed who the referral was going to, the referral fee was going to. So if I was supposed to receive a referral fee, then perhaps the firm would have assigned it to someone else for whatever reason. So what this is saying here, that it must go to, the referral fee must go to the person that it was assigned, and the assigning of the referral fee would be from the firm that is referring, that's providing the referral fee. And they're the only ones that can authorize a change in terms of who gets the referral fee, not the firm that it's going to, but the firm that's actually issuing the referral fee. So this was added to that agreement so that firms would know they could not change it without permission of the person providing the referral fee. Okay. And that's it. I think those are the most important things that we covered on the residential. That was some of the forms that we, as the residential agents, will typically run into. And so let's go entertain some questions. All right, so my question about buyer getting DD fee back about, was about 5D. Let me go back to 5D. All righty, let's go back. It's probably earlier in the, all right, so what this was talking about was that if there was a situations where with these high due diligence fees, and if buyers were wanting to back out, they were using the fact that they did not receive the RPOs at the time that they were making an offer. And at that point, they were requesting the DD. They were trying to make a case for the buyers to receive the DD back. And I guess it probably went down. I don't think it went to any type of courts, but there was some pushback or a lot of agents trying to work that angle, because it says here that the law indicates that they're supposed to get the upholds prior to making an offer. Okay, and they were saying that if I didn't get it prior to making an offer, then my clients should be eligible to receive the due diligence back. But what the clarification is that it does not have to be provided to you right at the time you make the offer. As long as it was provided to you prior to an offer being made, then the law applies. Meaning you cannot request your DD back and there's no breaking of the law if you did not get the thing right before you submitted an offer. If you got it prior to you making an offer, if you got it during the negotiations, even probably if it was at the house there when you did the tour and you picked up a copy, it was provided, then you cannot make a case saying that my buyers deserve their due diligence feedback based on the fact that they didn't get it prior to. Okay. Now, if you look at the second bullet, and it says buyer has not received the signed copy of the Residential Property Owners Association disclosure statement prior to making this offer, and shall have the right to terminate or withdraw the contract without penalty, including refund of the due diligence fee. Now, if you did not ever receive a copy, period, prior to, during the negotiations, if it was never provided, then yes, you would be, according to this contract, you would be entitled, the buyers would be entitled to receive the refund of the due diligence fee. Okay. All right. Meta says this comes into play, especially when working with unrepresented sellers, where seller may need to be prompted to provide this form. I agree. All right. Any other questions? I didn't know how long it was going to take me to go through it, but I felt like I wanted to bring out and point out some important things regarding the forms that we use. Any other questions? Got one. Can I go back over 4A? Sure. Let me pull up my notes real quick. Basically, what this is saying is, you know, 2 or 3 years ago, when we were, there was a contingency part of the contract. Basically, a buyer could say, I can't, you know, I have to sell my house first before I'm able to buy your house. So that was a contingent. So you enter into a contract contingent upon the buyer selling their houses. Well, what they're saying here is, in the last year or so, there may have been some issues because people were making these high offers for homes that may not appraise. Then if it didn't appraise, they would get a lot of complaints about the buyer should be able to get their due diligence back because it didn't appraise. Well, what it's saying here is there's no loan or appraisal contingency in offer purchase contract. So basically, if the thing doesn't appraise, that you're gonna have to pay the difference, or you're gonna lose your due diligence money. So it says, therefore, buyers advised to consult with the buyer's lender prior to signing this offer, and to ensure that the due diligence period allows sufficient time for the loan process and for buyer's lender to provide buyer sufficient information to decide whether to proceed with or terminate the transaction. So not only are we looking at over appraisals, but how long it took for the appraisals to happen. We know that at one point in time, appraisals were backed up, and it may have taken longer for the appraisals to be processed, and it may have gone beyond the settlement date. Of course, there's some rules there regarding that, but what it's clear what if they want you all to clearly understand that there's no contingency for appraisals. So you just got to work it out. So it's basically, so Meta says, so basically it's affirming the buyer's right to terminate for any reason or no reason and suffer the consequences, right? Yeah, I guess if you're speaking in terms, I don't know what you're speaking of, Meta, but if you're speaking in terms of this one, again, there's no appraisal contingency. So you got to work with your lender regarding that aspect of it, of getting the appraisal done in time, and also understanding that if the property doesn't appraise, then you're still on the hook because you signed the contract. Any other questions? We've got time, a little time. Any more questions regarding the changes? All right, we know and understand that there, if you're practicing commercial real estate, there is some changes done to forms on that aspect of it, as well as property management. There are some changes regarding the forms. And if you're doing any auctions, there are some changes regarding those forms as well. We've covered the residential forms to the best way I possibly could. I apologize if I didn't give you any more information, but I think what we covered was important. I think it's going to provide you with the needed information, the knowledge that you need as you go forward, particularly as we look at having these forms fully implemented in our practice. It's a 60 days that came out July 1st, so that means September 1st, all the forms should be in play, and we should be using them at that time. All right. Well, if we have no other questions, guys, thank you all for attending. Appreciate your time.